Good evening. I'm Melvin Raymond, attorney and counselor at law. Welcome to Raymond Law Live. Are you paying child support under, or receiving child support for that matter, under a court order or an administrative order? And has your financial circumstances changed significantly? If you are in that situation or you know someone who is in that situation, then you'll be very interested in the topic on today's broadcast. The topic on today's broadcast is modification of child support orders. Modification of child support orders. Now we're talking about administrative orders, that is, or orders, child support orders ordered by the state administrative child support agency. Here in Missouri, that is the Family Support Division. Or you could have, we're talking about court ordered support. And that would be usually occur when you go to court, either in a paternity case or a divorce case. In those cases, the court, if there are minor unemancipated children, then the court will issue a child support order. So that's the topic for today. Now, the non-custodial parent, that's the one paying support, could be paying support for a very long time indeed, depending on the age of the unemancipated child or children at the time that the administrative order or the court child support order is entered. The age of emancipation is 18 years old in Missouri and many other states, unless the child or children continue his or her higher education upon graduation from high school and enrolls in an institution of vocational or higher education not later than October 1st following the child's graduation from high school. And another thing that has to happen for child support to continue after 18 is the child takes the prescribed number of courses, usually that's full-time, attending a vocational or institution of higher education. 12 hours is considered full-time if they're not working, and if they're employed part-time, then the child is required to work or take at least 9 credit hours per semester while they are enrolled in school. If they do that, then the child support obligation continues until either the child reaches age 21, or they complete their vocational or higher education, whichever comes first. Now, if the financial obligation of the parent paying support, or for that matter receiving support, has changed substantially since entry of the child support order, it would be worthwhile, if you're in that situation, to consider seeking a modification of the child support order. Now, you should keep in mind that once a child support order is entered, the child support order and the amount of the child support will stay the same for until the child becomes emancipated, unless the parent obligated to pay the support seeks an order of modification. So when the financial circumstances change significantly, you should at that time seek to modify the child support and not wait until the child reaches emancipation. Once the child reaches emancipation, it's too late to try and recover any increased amount of child support, at least recover any amount of child support under the initial child support order. You cannot go back later and try and get it. You need to get it when there is a change in your financial circumstances. And that could be a change in the circumstances of either the parent paying support, or in some cases, the parent receiving support. In my practice, I have handle cases involving child support modifications filed by the custodial parent who is receiving the support because he or she may think that the financial circumstances of the parent paying support has changed. For instance, if there's been an increase in the income of the parent paying support, then that is considered in calculating child support. So it's not always the parent who has experienced a reduction in income who may seek a modification. It could be the parent also, and sometimes that is the case, that the custodial parent may seek a modification because of an increase, for instance, in the income of the parent paying support. Now, whether a court will grant a modification of a child support order depends. So the question is, when is a person entitled to a modification or a change of the amount of child support? Of course, if you file the order or file a court case seeking modification of a support order, the burden's on you, the moving party, to show first a change of financial circumstances, second, that the change is so substantial, and third, continuing, not temporary, such that the terms of the child support, the existing child support order, are unreasonable. So there's got to be a change of financial circumstances, and those changes again have to be substantial, continuing, so that the terms of the child support order are unreasonable. Now, what kind of things does the court take into consideration in deciding whether or not to modify a child support order? Well, one thing, and this is the most important factor, is a change in the financial condition of a party. That is probably the most important factor, a change in the financial condition of a party. Now that could be the party paying support, or also it could be the party receiving the support. Now a court could look at, and they will distinguish between, for instance, a temporary loss of earning power, as if, for instance, when you lose a job, as opposed to a permanent loss of employment. A permanent loss of employment would generally be considered a continuing change. If you lose your job permanently and that results in you getting another job which may pay substantially less than the prior job, then that will usually suffice to establish a continuing change rather than being a temporary change. Now, in some instances, a person may change jobs or be unemployed for a short period, and then they get reemployed and they change jobs. A loss of a job and a temporary unemployment wouldn't constitute continuing change. Continuing change is what the court looks at. Also, another thing the court considers is a reduction of income. That's another factor that they'll look at to see if the change is substantial. So if you, again, change jobs, for instance, and there could be other circumstances where you suffer a reduction of income, if that happens, then that could be another factor that the court would consider in determining whether or not to modify or modify, either increase or lower child support. So that's a factor. Other factors, an increase in income also could be a factor of the person paying support. So a substantial increase in the income of the person paying, the parent paying the support, could also be a factor. And in fact, that's what often triggers the custodial parent to seek a modification of a child support order, is when the parent obligated to pay the support has an increase in income. The court would also consider, and these are several different things that the court would consider in determining whether or not a party who is seeking a change or a modification in child support, whether or not they're going to grant the change. They consider the financial needs of the child or the children as to educational expenses, for instance, the cost of the child's recreation or clothing, even inflation. As children get older, expenses tend to increase for the child, but that does not necessarily mean there's going to be an automatic in a modification either up or down in the amount of the child support, because the court, in determining the amount of child support, they consider under Missouri law child support guidelines, and the guidelines do consider inflation. That is supposedly built into the child support calculations. Let me say, if you have any questions or comments, you can post them on our Facebook account. That's facebook.com/Raymond Law Live, and we'll take your questions and your comments. And also, I wanted to mention here that we invite you to let us know if you have any topics you want us to cover in future broadcasts. If you do, just simply email us at mraymondattorney@sbcglobal.net, or you can post them on Facebook, or you can send us a tweet at Twitter at Raymond Law Live. So that's how you can reach us. As far as questions, I think I have one. The question is, should the non-custodial parent request a modification if they relocate to another state or country? The answer to that question is, it is possible. The court that issues the child support order has continuing jurisdiction over the child support. So if a parent relocates then and they want to seek a modification of a child support order, usually the parent will have to file the modification in the court where that issued the initial or the existing child support order. So if you move from Missouri or change states and relocate, and you're seeking a modification either up or down of child support, then you will normally need to file the modification in the court where the order arose from. Now, there are circumstances where you can seek the modification in the court where you relocate or where you live if there's provisions in the law in the place where you relocated that will allow that. That is, they allow that based on your relocating and the court obtaining jurisdiction over the child. In most states, and including Missouri, the court could get jurisdiction over a child once the child has established residency, along with the parent, of course, in another state or wherever for 6 months or longer. So it depends upon the law in the state where you relocate. Some states allow that, and not all states. So it's a matter of state law. You would, of course, need to contact an attorney to find out whether or not the modification can be brought in the state to which you locate. Now, there is another way under Missouri law to establish a change of circumstances, and that's known as the 20% rule. The 20% rule, and that is a rule under the law in this state, the state of Missouri. Now, how does that work, the 20% rule? Well, as I mentioned before, child support in the state of Missouri is calculated either in cases of a court child support order or an administrative order. They use the child support guidelines under a particular court rule that is Rule 8801 of the Supreme Court. That rule includes the way you can calculate child support, and then there are some guidelines which establishes the amount of child support. So, under the guidelines, if there is a change of 20% or more, or let's say there's a change in income that will result in a change of 20% or more, 20% or more in the amount of the current support, the support the parent is paying now, then that is enough to establish a change of circumstances by itself. So that's kind of more cut and dried, the 20% rule. Again, when the court calculates support, the 20% rule applies to the court considers in computing the income, both the income of the parent paying support and also the parent receiving the support. So it's got to be the change has to be such that it would result in a 20% change in the amount of support that is presently being paid. So if you can get in under the 20% rule, then that's a good thing, and that will save you a lot of time in court and some attorney's fees. So that's a good thing, the 20% rule. And that rule again exists in the state of Missouri. Another thing is very important. I mentioned administrative orders, child support orders, and also court child support orders. Now, in some instances, the initial child support order may be issued from the administrative agency, and most states have administrative agencies that can initiate child support orders. In Missouri, our state agency is the Family Support Division, the Missouri Family Support Division. Now, the administrative child support order could happen if the custodial parent goes to the agency, the Missouri Family Support Division, and requests collection of child support. The Missouri Family Support Division, they're the agency responsible for enforcing the child support laws, and every parent is obligated, as we know from prior broadcasts, to support children, to support all unemancipated children or child. So if the parent goes to the Family Support Division and seeks the initiation of issuance of a support order, then that will start from the Family Support Division and not in court. And if the order starts in court, then that happens usually when a paternity action is filed, or in the case of a divorce and there are unemancipated minor children. So if the initial order comes from the court, then the agency, the Family Support Division, or whatever the state child support agency is, they cannot in Missouri, they cannot change a court order if the court order first comes from the court and not from the agency. So if the first order comes from the court, then you have to go to court to seek a modification of the child support. That's not true, of course, if the agency initiates the child support order. So it depends on whatever comes first. But an agency could never change a court child support order. They can't do that. In fact, the court child support order always trumps an agency support order. So, for instance, if you have a state or administrative agency child support order and you wish to get that modified, you can go to court to get a agency order modified, and the court order modifying either up or down the child support would be the order that trumps the state order. But it doesn't work in the reverse. That is, the agency cannot change a court child support order. So that's how that works. So that is some information about modification of child support orders. That's very important to many of you because, again, as we know, the obligation to pay child support could be very, very long. It could last up to 21 years, as we mentioned. So that's something that's very important to you, those parents of unemancipated minor children, or if you know someone who has unemancipated child or children, then this is a topic that's very important. And we hope that you are better informed on that issue. Child support modifications can be difficult, and it's advisable for you to obtain counsel, or at least consult with a counsel if you're considering trying to seeking a modification of a child support order. There are some risks, and you need legal assistance in deciding whether or not you want to seek in court to modify a child support order. And in order to modify the order, you must go to court if it's a court order. Now, if the initial order comes from the agency, you can seek a modification through the agency. One other thing about administrative agencies, the court standard, they have a different standard for determining modification. The court standard is, as we mentioned before, you have to show substantial continuing change circumstances so as to make the order unreasonable. But that's a different standard for the state agency. The standard there is if there's any change in the financial circumstances. And it doesn't have to be, again, substantial or continuing. Any change in the financial circumstances of the parties could result in a modification of a child support order if it's an administrative order as opposed to a court order. So that wraps up our discussion about modification of child support orders. If you have comments or questions, you can post them on our Facebook account, or if you want to reach us and with your comments or questions, you can reach us at our email, mraymondattorney@sbcglobal.net, or go to our Facebook page, facebook.com/Raymond Law Live, or you can reach us at Twitter. That's Twitter @Raymond Law Live, or you can call us at our office, area code 314-534-2800. Before we close, I want to thank all of you watching this broadcast live, and also those of you who will tune in later. We appreciate your tuning in, and we appreciate your interaction. So join us for our next broadcast on Tuesday, March the 12th, at the same time, 6 p.m. Central. And remember, when you fight, know your rights. See you next time.